Hi guys, it's Kathy. I hope you're doing well. Hold on, I gotta get this on Discord. Let's let people know I'm finally here. All right. I don't know how long the stream is gonna be because I don't know how much I have here. I'm working on it. So one more moving over. CJ just called me, booked me up because I fell asleep before I got all my videos moved over. So now I'm trying to get everything moved over as fast as possible. But I have two really good ones for Georgia, but only one of them is for today because the other one's not ready, and it's the better one. But I don't know. I guess it doesn't matter. Constitutional law doesn't matter anymore. But I think they might be breaking some major laws here, and I don't know why. There's no reason for it. There's no reason why they just can't indict these people. I don't. You guys have seen Judge Manning, her docket. How people are sitting in Georgia for 600, 800 days without being indicted before they're even indicted. Oh my gosh, Rebecca's here. Hi, back. So I don't. Do I think these guys need to be on the streets? No, I don't. But I also care more about being arrested and then sitting in jail for a couple years without a charge. No charge against me. But I don't know. You guys can tell me what you think when we get there. We're not there yet. That's gonna be last. I think first we're gonna go to a free house. I don't get this one. I mean, maybe she has reasons. Hold on. Maybe she has reasons, but I don't. I don't know what they are. We are in Indiana. I'm really curious. Yeah, a free house.
According to the law.
I'm getting rid of my intro and my outro. I'm getting rid of them because they're just more pain in the ass than anything else. So all right, I'm just gonna press play and then I'll talk. Here we go. Hi there.
Mr. Tokar, that is 2002 2308 EU 148. What's happening with the estate?
May I approach the bench, Your
Yes, sir.
Honor? I would like to show you a trail of correspondence. All that is required of the personal representative is that she sign the personal representative deed that conveys the property to her, signs the closing statement, has the other two heirs sign consents approving the accounting, and the estate is closed. But I have sent her several emails, attempted to call her several times, even left a couple of messages through a client of mine who is her landlord at some stables that she has, and Judge, it's like she has vanished off the face of the earth. She hasn't responded at all when we could have closed this estate approximately Christmas 2023.
This channel has never once seen slow mode.
In Ms. Farine, I'm not sure I'm pronouncing that correctly, but Farine or Farine, what is her relationship to the estate? Is she the personal representative?
She was, according to the last will that was there, she's the adult daughter of the decedent.
Is she also the personal representative?
Yes.
All right, in that case, what I would suggest that we do is we set this matter for further.
So in 2023 or 2022, it could be somewhere in that time, this woman's poor mother died. And she gets the house. All she has to do is sign some paperwork. She gets the house. And then we can get a hold of her to get her to sign this paperwork. But the judge has an idea.
That we issue a rule to show cause to the personal representative, refer and show cause why she should not be held in contempt for failure to fully administer this estate, and see whether that brings her out of the woodwork. I would suggest, Mr. Tokar, that you might want to get into the car and just drive out to the address and see whether there are any signs of life, to see whether there's somebody living there. That might be helpful.
I am surprised, though, Judge, she won't respond to emails. Her phone goes straight to voicemail. It is like she doesn't want to complete what is a profitable thing for her.
That's why we're going to send out this citation, because the words contempt of court tend to elicit action in people.
Thank you, Your Honor.
We don't really want to hold them in contempt. I don't really want to have the sheriff go out and seize her to bring her into court. We've got to get her attention, and usually this is a good way to do it.
I think since we have a signed compromise agreement between all the heirs, and just to make sure she will come in and do what's required. And Judge, did you want to pick a date now for the next hearing?
Yes. So we make sure we have service. It's about 4 weeks.
You too. 25th at 9:30.
Okay. You do. Okay. So they're going to hold her in contempt of court. But they're not really going to hold her in contempt of court. If you didn't hear the judge, he says, I don't want to hold her in contempt of court. I certainly don't want to put her in jail for contempt. I just need her to get over here and sign these papers. So we're going to tell her that she's going to be in contempt of court if she doesn't get over here and sign these papers. And get her free house. A free house. Okay. I'm going to go to Georgia now since Bill's here. So, like I said, I have a couple of these, but I turned it up, Chinny. Hold on. I have a couple of these, but we're only going to see one of them today. All right. It's not the best one, but it's one of them. I got to get to it.
Agree that we
CJ said I was too loud 2 days ago, so I turned it down. All right. I'm putting my microphone at the minimum. At the medium, right in the middle. That's where the microphone is right now. It's right in the middle of loud and soft. This is the one that we want to see. This is the better one, the girl with the white hair, but it's on my phone right now. I don't have it ready. I could show you this, but it's only like 5 minutes of it, and the rest of it is really good. Am I loud enough now? Does it sound better now? I'm going to go with Georgia.
Separately or two at a time, or how do you want to do it?
I don't care, I just want to go first.
Who is it, Ashley?
I don't care, CJ, what's his name?
Williams?
Courtney Collins is the first one?
Okay.
Oh, okay, never mind, I ain't got that person.
CJ, thank you so much for waking me up today. Thank you. Oh man, I'd still be asleep right now if CJ wouldn't have called and said, yay, get to work.
My list says you have Holly Moore and Patrice Williams, Mr. McLaughlin.
Now, I don't have Patrice Williams today.
She's here.
I'm gonna ask that Ms. Williams be continued until next time, because that one wasn't on my calendar, so we didn't pull histories or anything.
All right. Hey, I didn't know she was even existed until I got here today. All right, Mr. McLaughlin, let me be clear. Who do you represent?
I know for sure I represent Holly Moore right now.
Okay.
All right,
That's
let's do that one. Get
almost identical to the young lady.
all right, get Holly Moore out, please. And that is number 4.
I did, Kelly. I said, Rebecca's here. Hi, Beck. I did. Y'all are on me today. Leave me alone. Watch the video.
Sit right there.
Next up is position 4 on my bond calendar, case number 25R127M, as in Michael-MJ. You are Holly V. Moore?
Yes, sir.
All right, Ms. Moore, I'll note for the record that you are seated at council table with Mr. McLaughlin. Ms. Moore, your case is down today on my calendar for a bond hearing. By the fact that we're all sitting here today, I'm presuming the state is opposed to bond. Is that correct, Ms. Stanley?
Yes, Your Honor.
All right, well, go ahead and give me your argument, and then I'll hear from Mr. McLaughlin.
Yes, Your Honor. As I have put on the record previously, Ms. Moore wouldn't be entitled to bond because her case is indicted. The 90-day rule wouldn't apply. Ms. Moore is charged with 3 counts of racketeering activity, trafficking, multiple counts of gang activity, possession of marijuana with intent, and multiple counts of criminal attempt. The state is going to be opposed to bond in this matter today. We believe that Ms. Moore poses a significant risk to commit other felonies pending trial, as well as poses a significant threat or danger to the community. As I stated previously, under the gang statute 1615-4, that does require increased bail for gang charges, as well as those special conditions that I had outlined previously. As I said with the other defendants, if the court is wanting to set a bond in this matter, I would ask that it be no less than $300,000 with the special gang conditions and special condition that she be banned from DOC properties. I have had a chance to look at her history. It does appear that she currently has 24R225, that's Judge Caulfield's case, pending. a burglary in the first degree, it looks like. I did look in 2019, she had a possession of a Schedule II charge, and
I don't understand, Micah. Is it the answer to I wonder if? Because that's fine. I'm good with that. I was just wondering if. Is that what you're talking about?
I'll also state on her PI case, which is related to this RICO, she came before you on January 17th when we had a bond hearing. And those charges in the PI case were,
Who the hell checks their voicemail? No. All right, I'm going to check if I know how, I'm going to check my voicemail.
it looks like a few counts, maybe 2 counts of 42-518, possession of meth with intent, possession of a Schedule 1 or 2 with intent, and possession of marijuana, and possession of tools for the commission of a crime. The court did set a $250,000 bond on that case. As we stated earlier, it would be the state's position that that $250,000 could count towards this for the charges that covered, but that a new bond would have to be set on the racketeering counts, the gang counts, and the other charges that were not covered by that bond. But for the reasons that I have stated, you know, the state would be opposed to bond, and the reason I'm saying that she would be a significant risk or danger to the community is because this is a situation that involves being in possession of dangerous drugs, trying to get them into the prison.
While you're on your feet, I meant to ask this earlier, I forgot it. The cases that already have a PI number and may have been assigned to other judges, is the state going to move to withdraw those warrants or the PI cases, or how are you going to handle those?
So the PI cases that I had just referenced for Ms. Moore and Ms. Fordham, that is related to this RICO, but since we did the special presentment indictment, more charges got added. We are going to look at that issue, and I plan to address that once we get everybody picked up.
Okay. Mr. McLaughlin.
Your Honor, I could say just ditto, I guess, because you already heard this from Ms. Fordham. Ms. Moore has been in jail for 17 months on a $250,000 bond.
She's been in jail for 17 months, right? The lawyers don't even know what the charges are. She's been in jail for 17 months and has not been charged with a crime. The lawyers are guessing what the charges might be. They're guessing it's gang, they're guessing it's drugs, but there's no, they didn't tell them what she's in jail for. There's no charges. There's no indictment. 17 months. She's in jail. Now, I mean, if she is gang and she's drug dealing, things like that, her sentence is going to be longer than 17 months. And they're trying to get drugs into the jail, which is a big deal. So, yeah. So she's not the only one. The other one is better, but it's just not ready yet. That's tomorrow.
And I know we're streaming, try to keep it PG and get extra court.
Micah, that's freaking hilarious. I couldn't understand who died. It sounded like Apple died. Apple? April? I don't know who died.
Miss Moore, at the time of her arrest and now, didn't have a pot to pee in or a window to throw it out of. She was homeless. She was at the place where she was arrested to take a shower because they had running water.
I remember that. I remember you told me that in January.
She has three kids.
Yes, she has a bond, a $250,000 bond. Now, I mean, she really is a sucky drug dealer. She can't afford that, but she's been in jail for 17 months, so I'm guessing she can't afford it. I don't know. Maybe she can, and she's just being stubborn.
She was married to my cousin Chris, And I think two of the kids, the oldest two, the 17-year-old and 14-year-old, are hers and Chris's. She has a 12-year-old with a guy I don't know if she ever married him or hooked up with after that. But anyway, she's been in jail 17 months, Your Honor. She can't make a bond. I know these are RICO charges, but there's really, I don't think that's anything special. I mean, anytime somebody does cocaine, they are technically violating the RICO Act because you don't make cocaine at home. You don't grow the coca plants. You don't refine it. So every human being that's charged with possession of cocaine in this county has violated the RICO statute. I don't think that's a reason to deny somebody's bond. There's nothing magical about those 4 letters, and it's 4 letters, not 5. It should be RICO.
I'm sure there's an H in there.
I think it's overly cumbersome, burdensome, and I think it violates the Constitution. I don't know what I'm defending against today. And I know you told us all to brief it. But when you show up to court, what you're obligated to do with a jury and a judge is all we have to base our defense on is what's alleged in that indictment, the conduct in the indictment. I don't give a damn what the charge says. If the conduct in the indictment is not met, then that should be an acquittal, should be a dismissal. If it doesn't say that she did this on this date in violation of this code section, then I think Your Honor should grant bond today for Ms. Moore. I think she meets the qualifications. She's from here. She's got nowhere to go, nowhere to get there. She has children here. She had all her families here. Your Honor, she couldn't run if she wanted to. I mean, she'd have to run on foot. I don't know how she could get anywhere. She lived in Helena in my Aunt Iris's house the first probably 20 years of her life, and for the last 10 years, she's been in and around Helena in that same area, probably a 3-block radius. The only time I've seen her out of it is when she got arrested, and I'd seen her going to that house before then to go take a shower. And I just, Your Honor, this is a tough one. It's cumbersome. It's going to result in us probably having to conflict 20 people to conflict attorneys. And it's going to take a while, and that's going to cause Ms. Moore to suffer. She's been in jail 17 months for the same underlying conduct on a $250,000 bond. And that just ain't right. I don't care how you cut it. That ain't right, John.
It's not right. I agree. It's not right.
All right, Ms. Moore. And I do remember most of what Mr. McLaughlin said. He said it back in January. And I remember that now. I remember that part about your Mr. McLaughlin said you were at that.
Yes, Judge, that made it better. Yeah, I remember you from January. I remember, 4 months ago talking to you about this, but, we still don't have a charge yet.
Residents for the reasons stated. But as I said back in January, Ms. Moore, this is a bond hearing. It's not the trial. And I don't know if you remember all those details, but the only issue before the court today is whether you meet the statutory requirements for a bond. And there's essentially 4 of them in Georgia, and all the attorneys have hit on them, and you know what they are. I'm sure you've gone over it. And that's what I've got to try to figure out. Is there something that this court can craft together to protect your interest as well as the community and the prosecution of the case? As I sit here right this minute, Ms. Moore, I don't know what I'm going to do. As I'm sure you've noticed, I got other cases I got to work through today, and I'll get a decision out. And as I already stated, get the briefs filed in each one of these cases so I can see what all the attorneys think about how to release the indictment, if at all. One more thing while you're out here this morning, I want to make a comment on it. I don't think I said this back in January. I haven't said this in a long time, but when I first became aware of this case, when the special presentment was brought into the court, I was reminded of something. Mr. McLaughlin and I have stood shoulder to shoulder over in federal court in Dublin. That was a long time ago, wasn't it, Mr. McLaughlin? And the Southern District of Georgia would indict, 30 or 40 co-conspirators at a time. Now, you talk about confusion. He's standing there with all these defendants and all these lawyers, And I was reminded of that. As again, we talked about bringing you all in here today at once, but I got talked out of that. That's probably a good idea. But Ms. Moore, I want you to just understand.
Judge, I love you, but that wasn't funny. Nothing about this is funny.
I'm keenly aware of your situation, and I've just got some hard decisions to make, but I'll notify Mr. McLaughlin, and he'll let you know in due course. That's it for today, Ms. Moore. You are excused. Thank you.
Well, there we go. After 17 months sitting in jail waiting to be charged, she is going to hear the answer later about her bond. What? I'm just saying, guys. If it can happen to one person, it can happen to anybody, guys. I don't know. Maybe she's a real bad guy. Maybe she's, a gang member. Maybe, the RICO Act was built just for her. That's fine. You can charge her with a crime. You can charge her with a crime. But, oh well. She's not in there alone. There's a whole bunch of them in there. It's been like this. Not just one person. The whole gang. The whole gang is together. Oh, wow. Okay. This is part 1. Oh, we got lovers in crime. Next, we got lovers in crime in Jersey, in Atlantic City, guys. I love going to Atlantic City. I love casinos. When I was 21, the very first thing I did when I was 21 was walk into a casino. I was there at midnight with my ID in my hand. All right.
Counsel, are we ready to proceed?
Yes, Your Honor. I just need that supplemental report from Ms. Hess. Thank you, Ms. Hess.
Welcome. Good morning. My name is Judge Jorge Coombs. Today is Friday, April 4th, 2025. The time is 9:46 a.m. Going on the record on the matters involving State of New Jersey versus Joseph Lenio. These are complaint warrant 2025-1156-0102, complaint warrant 2024-163-0103, and complaint warrant 2024-162-0103. With regards to the first matter, the 2025 complaint warrant, we'll first have a hearing to consider the prosecutor's motion seeking pretrial detention in that matter. The other two matters from 2024 are scheduled for violation of monitoring hearings. All hearings are being conducted virtually today. Counsel, your appearances, please.
Thank you, Your Honor. Assistant Prosecutor Hess appearing on behalf of the state this morning.
Good morning, Your Honor. Box on behalf of Mr. Lenio.
Defense counsel, may we mark this as your client's first appearance, and has he been advised of his rights, including his appellate rights?
Yes, Judge McKennedy has been advised.
She wasn't charged. This is just conversations that they were having about what she might be charged with based on the affidavit.
Mark that first appearance as complete. Court is satisfied. The defendant has been advised of his rights at today's hearing. I've reviewed the following: complaint warrant, preliminary law enforcement incident report, and attached affidavit of probable cause. We've also reviewed public safety assessment with a PSA run date of the 1st of April, 2025, run time of 8:44 a.m. We also reviewed the aforementioned prosecutor's motion seeking pretrial detention, along with state's reports from the police department involving reports from Officers Gradell, Sanchez, and McKinney, dated the 22nd of March 2025 and the 3rd of April 2025. Prosecution, is there anything further the state intends to rely upon for today's hearing?
No, Your Honor. State would ask you to mark the Complaint one, preliminary law enforcement incident report, certainly S1 collectively, that PSA is S2, and the Atlantic City Police reports as S3, please. And move for their admission.
Defense counsel, any objection?
No objection, Judge.
So marked and moved. Is there anything further that the defense intends to rely upon for today's hearing?
No, Your Honor.
Does your client challenge probable cause?
Judge, due to the low standard, we won't challenge probable cause for the purposes of today's hearing.
Even though there is a stipulation as to probable cause by the defense, prosecutor, if you could please set forth the facts relied upon to establish probable cause in this case.
Yes, Your Honor, thank you. At this time, the state would submit that on March 21st, 2025, within Atlantic City, the defendant, Joseph Lenio, and his co-defendant, defendant Alicia Edwards, were captured and observed on Resorts Casino surveillance footage, roaming several hotel room floors. The couple was captured checking hotel room door handles, ultimately successfully gaining entry into one hotel room that was registered to the victim that I identified by the initials of SN. The Joseph Lenio's co-defendant, Miss Edwards, then is captured entering SN's hotel room, presumably retrieving keys to a 2020 Toyota RAV4 with a no New Jersey registration that belonged to SN. After obtaining those keys, the defendant, Joseph Lenio, while co-defendant Edwards entered that hotel room, the defendant, before Your Honor, Joseph Lenio, was captured on surveillance footage, pacing back and forth in the hallway, essentially acting.
She doesn't. She has a $250,000 bond, but there's no charges yet. There's no indictment. There's no charges. They just don't have it. They don't have it for them yet. They have probable cause based on the police report. They have probable cause based on that police report, and they gave him a bond, but they don't have charges yet. You'll see better tomorrow when the next one comes up.
He was a lookout for his co-conspirator. The victim, SN, confirmed that no one other than his significant other who was with him had authority or access to gain that room. And again, ultimately, their motor vehicle, that Toyota RAV4, was subsequently taken and located the next day after being entered into NCIC. It was located at nearby Absecon Days Inn Hotel on the 22nd. Your Honor, the defendant had no authorization to enter that hotel room, certainly supporting those charges for burglary, certainly had no authorization to take that motor vehicle nor to ride in it, and based upon his actions, was in violation of the listed charges.
Probable cause is a relatively low standard. Probable cause is a well-grounded suspicion that a crime has been committed and that the defendant committed the crime. With respect to the issue of probable cause in this matter, the court having reviewed the state's exhibits, S1, S2, and S3, along with having carefully considered both the stipulation by the defense as to probable cause as well as the recitation of the alleged facts placed on the record by the state, the court finds and concludes that the state has established probable cause that this defendant is an eligible defendant and that he committed the charged offenses. Specifically, there's reason to believe that defendant Joseph Lenio on the 21st of March 2025 committed the third-degree offense of burglary entering a structure unarmed, fourth-degree unlawful taking of a means of conveyance, specifically a motor vehicle, fourth-degree unlawful taking, means of conveyance joyriding, third-degree theft by unlawful taking, a movable object having a value of between $500 and $74,999, and third-degree conspiracy to engage in conduct constituting a crime, specifically the unlawful taking of the motor vehicle. The court, taking into account the recitation of the alleged facts as placed on the record by the state a moment ago, finds probable cause is found for the charges to issue. I'll now hear from the state on the issue of detention.
Thank you, Your Honor. At the time, the state would argue that the PSA certainly properly recommends no release as to defendant Joseph Lenio due to his repeated arrests while on pretrial release, which scores him an appropriate 5 for risk of failure to appear on the risk scale, as well as a 4 for risk of new criminal activity. He has certainly demonstrated his risk of danger based upon his actions before you in the current instance. He and a co-conspirator essentially proud hotel room quarters, looking for a target. In a coordinated effort thereafter, one of those co-defendants entered the room, unlawfully looking for something to steal, choosing to steal the keys to a victim's vehicle. They subsequently then proceeded to take that vehicle unauthorized. The defendant's risk of danger is certainly also amplified by his indictable convictions in Wyoming for forgery, as well as the defendant's 16 pending charges from 7 separate incidents in just the past 7 months. They include aggravated assault, endangering, theft, multiple counts of theft, as well as criminal mischief. His risk of flight, as well as obstruction, are also demonstrated by his own actions, including his pending charges for resisting, 2 counts of resisting, hindering, obstructing, as well as a serious second-degree eluding, in which the defendant elected to flee a motor vehicle stop, also struck a Brigantine police officer in that incident. Your Honor, his risk is further amplified by the fact that he has committed the instant offenses while he was already on the highest level of pretrial monitoring in level 3 for 2 separate cases that he had pending here in Atlantic County. And in addition to his own actions.
So he was trying to steal a car and he hit a cop, it sounds like, with the car, right? My sister was burglarizing Walmart. And the security guard came out to get her, and she hit him with her car, right? She was charged with that at one point, but it's nowhere on her record right now. Nowhere. She burglarized 3 houses on my street right here, and she was charged at 99 counts that one, because they counted her for burglary for each and every item that they could figure out, she stole. So she had 99 counts of burglary. That's not on her record anywhere. I was looking at her record today, and like 50% of her stuff is just gone. And I don't know why. Now, I understand. I don't know. I don't know if this is illegal to say. I don't know if this is obstruction. Maybe not. You know what? Hypothetically, maybe he could get his charge taken off of his record if he were a confidential informant. Maybe if he were a confidential informant, he could get some of his stuff taken off his record. But if he was a confidential informant years ago, and then, why would everything just disappear off his record right now? There's no way. There's no way he would be able to get anything expunged, because he's always in jail and committing crime. Always, right now. Right this second. So, I don't, these are felonies. They don't just fall off your record. I don't get it. She ran over a security guard with her car and was charged with it. And then it's just gone. She went to jail and now it's just gone off her record. I was just wondering why. It just doesn't make sense.
Those very charges that he is now facing are a clear example of his inability to abide by court orders or to abide by any conditions imposed on him by pretrial services. Your Honor, for all those reasons, the state would respectfully request that the defendant be detained pending resolution of these charges, as no non-monetary bail could assure his appearance in court the assurance that he would not re-offend or commit new criminal offenses, or that he would appear before Your Honor.
I'll now hear from the defense on the issue of detention.
I am going to ask you to release Mr. Linneo on conditions. There's a few reasons for that, Judge. First, the nature of these specific charges. Judge, we're looking at 3rd and 4th degree charges. There is not a presumption here, especially with someone with Mr. Linneo's record. Mr. Linneo has only one indictable conviction with an offense date of 1984, Judge. I do see the pending charges. I just want to know that these all look to be in the last year, from this, maybe the last 7 months. So there is a long period of time where Mr. Linneo is law-abiding and able to be a productive member of society. And I would argue to Your Honor to take that into account when you're considering whether or not Mr. Linneo can be released on conditions. I want to know he also doesn't have any prior violent convictions. Mr. Linneo has never been to prison. I do have an address for Mr. Linneo. Your Honor, he is from New Jersey. His parents live in New Jersey. The address I have is for the DMV area, but I just want to note that he does have ties to this area and ties to this community. Mr. Linneo proffers about the incident that he was told by the co-defendant that the vehicle was hers and that she was going to take him to get some money that she owed him. And that was his understanding of what was happening. And then he was found charged with these offenses. Mr. Linneo has a history of working. He advised me that he's been in the construction business for the majority of his life. He does have 3 adult children that he raised and provided for. He does not have any medical issues diagnosed, but he has been complaining of some really intense leg pain. Judge, when I saw him in court this week on his other case, he advised me that he was having some really intense leg pain, and he said that has continued to persist while he's been at the county jail. He advised me regarding his pretrial services he's already on, that he does reach out to his officer routinely as he's supposed to, and that he's been in touch with her, and that he has been consistent with that, Judge. Your Honor, considering the nature of the charges, considering life profit, considering Mr. Linneo's lack of criminal history, though I do see as pending charges, I am going to ask for Mr. Linneo to be released on conditions. I do think there are conditions that can be put into place to satisfy the jury. Thank you.
Anything else from the state?
No, thank you.
So the court's ruling on the prosecution's motion seeking pretrial detention. The court has heard the arguments of both the state and the defense, as well as having considered the state's exhibits that were previously marked and moved S1, S2, and S3. In particular, the court reviewed S2 more closely, and from it, the court finds the defendant is 61 years old. He has ties to the local community, specifically the Brigantine area. The defendant has a prior history of employment in construction, although it's unclear whether he's currently employed. In reviewing the PSA determinations, the court notes the defendant is on pretrial monitoring at the time of the current offense. He's on level 3 out of Atlantic County. Again, that's on complaint warrant 2024-163-0103, and the other matter complaint warrant 2024-162-0103. I don't see any probation parole. He doesn't appear to have any active warrants. The PSA scores him at a 5 for risk of failing to appear and a 4 for new criminal activity, which is on the higher end of the scale. PSA recommends no release recommended due to repeated arrests while on pretrial monitoring. The court analyzes this matter as it does with others of this nature under the triad of 1, the risk that the defendant poses to fail to appear at a future court proceeding, the danger or risk the defendant poses to the safety of a particular victim or the community at large, and finally, the risk that the defendant poses to obstruct the criminal justice process going forward. In doing so, the court notes that at the time of the offense, the alleged offense, the defendant had 16 pending charges, including but not limited to some severe charges, including a second-degree aggravated assault, fleeing on a law enforcement officer that was mentioned by the state. Additionally, a second-degree eluding with risk of death or injury to any person. Of the pending charges, those 16, 3 are of the violent nature, 1 being that second-degree NERA charge. Defendant has 1 prior indictable conviction for forgery. It is from 1984, and it is out of state, in the state of Wyoming, which the court takes into account. The court also notes the defendant has failed to appear 3 times within the last 2 years, with warrants issuing from March of 2025. However, he does not appear to have any prior failures to appear that predate that 2-year mark. The defendant does not have any domestic violence restraining orders, and it does not appear that he has any noted juvenile history. Again, as I said earlier, he does not have any active warrants or detainers. Court gives the recommendations of the PSA great weight regarding the triad of risk of failure to appear, safety of victims in the community, and risk of obstructing criminal justice process. As to that first prong, the court notes that defendant has failed to appear 3 times within the last year, 2024, and that is a concern. Although I do understand that there was a period of time from 1984 to approximately September of 2024, where it is asserted that the defendant was law-abiding, and since that time there appears to be an increase in alleged criminal behavior.
Judge, I went all year in 1992 without committing one crime. So you can just leave me go now. Just let me go.
Additionally, the court notes that 1984 conviction does show the defendant has possible out-of-state contacts in another state and increases the risk of flight. With regards to the second prong, the court places great...
I'm not in jail, Anna, and neither are you. So that's good. It's a good starting point for a Monday.
Weight on an emphasis on prong 2. That is the risk the defendant poses to a particular victim or community at large. Although there is no particular risk or personal relationship alleged between this defendant and the alleged victim of this crime, it appears to be a crime of a random crime as to a random victim. That is a concern for the court, as it finds the defendant poses a risk to the community at large. Again, although there are no current violent...
I don't understand what that means. Go several years in a row without breaking a law? Come on. Let's be reasonable. Kelly, let's be reasonable about what we're going to do. 1 whole year is a long time. Ask any 4-year-old, 5-year-old. It's like forever.
Offenses, there is a pending offense that is a violent charge, and a near offense, and 2 additional hindering and assault by auto related pending charges. That poses a concern for the court. Again, the court, pursuant to NJSA 2A:162-20, can also consider the weight of the evidence, the alleged evidence in the case, including video surveillance in this case, showing the defendant and the co-defendant on multiple floors of the casino trying doors to rooms, eventually seeking and obtaining access to the alleged victim's room. And additionally, the court will note that the police reports note that supervisors at the casinos identified the defendant and co-defendant from prior videos within the casinos. That increases the risk that this is ongoing behavior by the defendant and co-defendant. Finally, the motor vehicle was found at a motel in Absecon. The court can take that into account and finds that it is a concern that the defendant's behavior or alleged behavior poses a risk to not only strangers but law enforcement due to not only the pending but the current charges. Finally, the court places great weight and emphasis on the third prong of the triad. The risk the defendant will obstruct the criminal justice process. Amongst his pending charges include endangering, obstructing, resisting, and hindering charges. All
I'm 100% sure you would have to do all the work. You would have to build a hut. You would have to get the food. You would have to boil the water.
which are concerned for the criminal justice process going forward. Again, amongst those charges show allegations of resisting and using force and fleeing with law enforcement officers. The other concern is that the defendant has 16 pending charges, not including the current charges that were incurred from September of 2024 to present, showing that the defendant does have a risk of escalating criminal activity. With all that taken into account based upon the totality of
That sentence, the last part of that sentence, that was me being as below the belt as I'm going through a divorce, okay? This was a while ago. I'm going through a divorce, and my ex-husband is very tiny. He's a very, very tiny man. He's shorter than me. And we're having an argument about the kids. Every time he opened his mouth, I can't even finish this story. Every time he opened his mouth to try to talk, I would just point up at this guy and play. I think I won the argument. I don't know.
circumstances, including a detailed review of the defendant's criminal history, the recommendations of the PSA, and the facts and circumstances of this case, the court finds the state has established that no amount of monetary bail, non-monetary bail conditions, a pretrial release, or a combination of monetary bail and conditions would reasonably assure the defendant's appearance in court when required, for the protection and safety of any other person or the community at large, or that the defendant will not obstruct or attempt to obstruct the criminal justice process. The court finds the state has met its burden here by clear and convincing evidence based upon the documents presented to the court, including the recommendations of the PSA. Therefore, detention is ordered. Defendant has 7 days to appeal, and sir, you shall be afforded a reasonable opportunity for private consultation with your attorney prior to the next court date. That is on the 19th of May, 2025, before Judge Taylor. Anything else from the parties on this matter?
No, we just have the motion to revoke outstanding if Your Honor will be hearing it.
Defense counsel, anything further on the motions to revoke release?
Judge, I already raised my arguments earlier, but I think at this point, after your decision in the arguments, whether it will be moved, it's almost a procedural issue.
State anything further?
Your Honor, state would rely on the certification to revoke pretrial release that's been filed.
Court having reviewed the arguments of counsel, both in the certifications and on the record today, on complaint warrant 2024-162-0103, the court finds that on the 2nd of October 2024, Joseph Lenio was arrested for 4th degree obstruction, 3rd degree resisting, 2nd degree aggravated assault.
I got this. So, one of the worst things I did to my ex-husband, that was an accident. We're getting a divorce. We're arguing about something, probably about the kids. I don't know. But he's such a tiny man. He's shorter than me. He's just a tiny man. So every time he would try to talk, I would point to the air and say, the plane. Oh God, he got so mad.
Assault involving law enforcement, 2nd degree resisting arrest, eluding in a motor vehicle, posing a risk of death or injury to any person, 3rd degree hindering, using force, a disorderly person's assault by auto, and a petty disorderly person's disorderly conduct. On the 3rd of October 2024, Judge Andrew Cafero ordered the defendant be released pretrial and monitored by pretrial services. As a result of the arrests, including the recent arrest on the 21st of March 2025. The court finds that termination of pretrial release conditions and monitoring is appropriate, and therefore the court will order the defendant's pretrial release conditions and all monitoring is hereby terminated. Anything further with regards to complaint warrant 2024-163-0103?
No, thank you.
Counselor State?
Yeah.
On the 3rd of October 2024, Joseph Lenio was arrested for third-degree possession of CDS. On the 4th of October 2024, Judge Vincent Morrison ordered the defendant to be released pretrial and monitored by pretrial services.
Now, this poor man went all those years without committing any crime, and now he has crime after crime after crime after crime after crime. In 1 minute and 22 seconds, I'm going to show you why.
Again, he was on pretrial monitoring level 3, which is the highest level of monitoring, barring electronic or home detention. As a result of his arrest, including the most recent arrest on the 21st of March 2025, the court finds that termination of pretrial release conditions and monitoring is appropriate. Therefore, the court will order that defendant's pretrial release conditions and all monitoring is hereby terminated. I'll sign those 2 amendments to pretrial release order dated today. Anything further from the parties?
No, Your Honor, thank you.
No, Judge.
Excuse me, Your Honor, I would just note that there are violations of monitoring too, which I would assume would be found.
I do find violations of monitoring under both of the complaint warrants 2024, the one ending in 162 and the other one ending in 163. Anything else, court staff?
No, thank you, Judge.
With that, we're off the record on this matter.
Sir, you can leave. But that's about the only thing we agree on. The proofs are not strong in this state. We've only been in the case a day or two, but we have to do investigation and discovery. But I don't think the proofs are strong as to conspiracy or as to any burglary. The elements that.
I don't know how this guy can get away with saying this. This is her lawyer. He's supposed to advocate for her, but he's not allowed to lie, is he? He's not allowed to lie about it. There's no proofs of burglary. There's video. She had the car. Anyway, this is the girl. This is the reason that man started criminalizing again. Criminalizing.
The state's going to have to show as far as burglary is concerned. She's not a threat to the public whatsoever. We're asking that the court disregard or gives very limited weight to the PSA recommendation and release her on conditions such as remain law-abiding, she'll stay out of all Atlantic City casinos and have no contact with co-defendants or any alleged victims.
Are you guys having a problem understanding him? He's saying that there was no evidence of her burglarizing anything, and she's not a threat to the community. And he wants her out of jail.
She was the reason that I say that we don't agree is because I haven't seen any evidence of 9 pending charges anywhere, and Miss Edwards recalls some type of defiant trespass charge. She was vague about whether she's even on pretrial monitoring, but even if she is, she's willing to abide by these conditions. She's not a threat to the public at all. There's no violence involved in this offense, and there's no.
She's 41 or 42. So she has to be a blonde. There's no way that's gray. Is that gray? She's in her 40s.
No violence in her history whatsoever. Although she doesn't have children, she works as a dog trainer in a self-employed business for some 12 years. So that is completely out of character with somebody who is a threat to the public. If she's run a business for 12 years as a dog trainer in or around Manassas, Virginia. So we're asking the court to take that into, she needs to really get back to that business. We're asking the court to take that into consideration. These are all third and fourth degree offenses. There's no presumption of incarceration that I know of. We, as I say, we need investigation and discovery, both as to this tape, this security tape, as well as the her criminal history or lack of criminal history, that we have disagreements with the.
Have gray, yes, but that is full blown gray, or she has to. I'm going with she's a blonde. Although, like, West Coast, there's a lot of blondes. East Coast, not so much. I'm going with she's blonde, and not full blown gray at 40.
With the state regarding, so we asked the court again to release her on.
Terry, you did that to her. Terry, that was you.
Conditions. She'll remain out of all Atlantic City casinos, and she'll avoid any contact with co-defendant or victims. We would, I think that the defendant is a very good bet to appear. Probability of at all proceedings that she's required to appear at. She indicated as such to me, and that she would comply with all these conditions. So we'd ask the court to go against the PSA and give this woman a chance to get back to her business, and then we can probably bring this matter to a conclusion fairly quickly, particularly if the state provides the tape. I don't know what the tape's going to show, but it's probably not going to show have any proofs of conspiracy with the co-defendant in any event, or any proofs of burglary. The defendant has given me some exculpatory statements.
The tape showed her and the last guy we saw going door to door to door to door to door in the casinos. I don't know which casino. Normally, all those hotel doors lock automatically, so I don't understand how this happened, but they found one that was not locked. And they went inside, and they found some car keys, and then they stole his car, or her car. That's what they did.
About having consent to the keys to the car and so forth. So there's really a lot of fogginess or facts in dispute regarding the underlying charges. Thank you.
Anything further from the state?
No, Your Honor, thank you.
So the court's ruling on the prosecution's motion seeking pretrial detention in this matter. Court has heard the arguments of both the state and the defense. Also had an opportunity to review the state's marked and moved exhibits, particularly as to the PSA. In reviewing all the materials, the court finds the defendant is 41 years old at the time of the current arrest. She's not a local resident. There is an indication that she works with dogs in her home state of Virginia. There's no indication that she is a caregiver of any children. In reviewing the PSA notes the defendant is not on any pretrial monitoring, probation, or parole. However, she is on pretrial release of some form. Additionally, the court notes and is quite concerned that the defendant has two warrants. The defendant is a fugitive from justice in both Fairfax County, Virginia, and Leesburg, Virginia, around the DC area.
She's shocked that he might not let her out. She's in shock right now. She doesn't understand why.
Additionally, the court notes that the public safety assessment scored her at 3 for failure to appear and 3 for non-criminal activity, which is in the middle of the range. The PSA recommends no release recommended due to arrest while on pretrial release. The court analyzes this matter as it does all such matters under the triad of the risk that the defendant poses to fail to appear at a future court proceeding, the danger the defendant poses to the safety of a particular victim or the community at large, and finally the risk that the defendant will obstruct the criminal justice process. At the time of the arrest, the defendant had 9 pending charges. both in the state of New Jersey and the Commonwealth of Virginia. They stem from three separate offense dates, one from 2020, and May of 2020 in Virginia, and then two other from 2023, June of 2023 in New Jersey for theft by unlawful taking, disorderly persons offense, and then 6 additional charges from an offense date on the 6th of July 2024 in New Jersey, including credit card theft, hindering, drug paraphernalia, shoplifting, 3 charges of shoplifting. With the exception of the credit card theft, the remaining charges are all disorderly persons offenses. There are no violent charges, no NERA-related charges, no domestic violence-related charges, and the court takes that into account. Defendant has no prior disorderly persons convictions. However, she does have one prior indictable conviction in the second degree for manufacturing and distribution with intent to manufacture or distribute CDS, specifically methamphetamine, and that is a second degree offense out of New Jersey. That was in 2008. Defendant also has never failed to appear in court in the past and has never been incarcerated for a period of more than 14 days. Defendant, as I indicated earlier, is not on any pretrial monitoring or probation or parole. She does not have any domestic violence restraining orders against her. And she does have those 2 warrants out of the Commonwealth of Virginia. The court gives the recommendations to the PSA great weight in this matter. Regarding the triad of risk of failure to appear, that first prong of the triad, the court will note that although the defendant has never failed to appear at a court proceeding in New Jersey in the last 2 years, or in the period prior to 2 years, she is a fugitive from justice in Virginia and the DC area. And this goes back several years. And again, as I noted, that offense date is from 2020. Again, the instant charges are relatively low in degree. There's no first or second degree. And again, there is a presumption against detention in this matter. Again, no NERA-related current charges, no domestic violence or Graves Act-related charges. However, in looking at the second prong of the triad, the danger that the defendant poses to a particular victim in the community at large, the court is concerned and gives great weight to this prong because the allegations in this case are that defendant continues and had pending charges for theft, shoplifting, again, burglary, and theft of a motor vehicle, joyriding, and it appears from the facts as articulated by the state, the defendant is willing to using a co-defendant allegedly steal from strangers within the community, repeatedly going to multiple floors within a casino, trying doors, and then entering rooms of complete strangers. As such, the court does find that the defendant poses a danger to the community at large. Additionally, her previous criminal history from 2008 was a manufacturing or distribution CDS charge of methamphetamine, which is also a concern to the court. The third prong, the risk the defendant will obstruct the criminal justice process. The court also gives great weight to this prong. Defendant has not only failed to address her charges in the Commonwealth of Virginia, but she also has numerous pending charges out of the state of New Jersey that are similar in nature to the current charges, which the court is concerned show that even though she has pending charges, that her criminal behavior appears to continue unabated by the fact that she has pending charges. I'm also concerned that amongst those charges include hindering, a pending charge of hindering, which goes directly towards obstruction of criminal justice process. Additionally, 7 of those of the 9 charges are in the state of New Jersey. They're relatively recent, 2003, 2004. And again, despite being on pretrial release, it appears the defendant's alleged criminal behavior has continued unabated. The court also considers the defendant has no community ties to New Jersey, no work history in New Jersey, no family ties in New Jersey, and in reviewing the alleged evidence as articulated by the state, there appears to be video surveillance from the casinos, as well as the statements by casino supervisors identifying the defendant from prior incidents at the casinos, and there was the use of a co-defendant. For those reasons, the court finds that based upon the totality of the circumstances in this case,
Say happy birthday.
including that detailed review of the defendant's prior criminal history, the recommendations of the PSA, and the facts and circumstances of this case, the court finds that the state has established that no amount of monetary bail, non-monetary bail, conditions of pretrial release, or a combination of monetary bail and conditions would reasonably assure the defendant's appearance in court when required. Again, the court finds she's clearly flight risk based upon her state of residence and her warrants as a fugitive from that state. The protection of the safety of any other person or the community, and that the defendant will not obstruct or attempt to obstruct the criminal justice process. The state has met its burden by clear and convincing evidence based upon the documents presented to the court, including the recommendations of the PSA. Therefore, detention is ordered. The defendant has 7 days to appeal and shall be afforded a reasonable opportunity for private consultation with counsel prior to the next court date, which is the 19th of May, 2025, before Judge Taylor. Anything else from the parties in this matter?
Thank you.
Well, thank you, Your Honor. If my client can hear me, I would like her to advise me if she's going to have Virginia counsel work on these charges in Virginia, and if so, have them contact me. And also let her know that I will be in this coming week to see her in the jail.
Ma'am, you can leave the booth.
Thank you. Thank you, Brett.
Thank you, Ms. Bonnie.
Hi, Chaos. Okay, I got one more clip today that's like six minutes long. And then that's it. I hate thieves. Like, I do. Like, everything I've ever had growing up was just stolen from me because my whole family are freaking criminals to the core. What in God's name? I ordered some pretzels for breakfast because that's what I wanted. Soft pretzels. It's like a whole big, Jesus Lord, there's a lot of pretzels in here. My God. Anybody want a pretzel? Not what I ordered. They gave me so many pretzels. Oh my God. They can't have extra because it's 6:30 in the morning. Tonya, how old are you going to be? Hold on. Oh, 60. Yes, you're going to be 60. All right. Yes, you can have as many as you want. I'm never going to eat all this. Can't believe they sent this to me. This guy. I just thought this was comical. It's coming. Give it a second. Bothering you? It should not bother you.
Okay, so I made the single turn and I parked. And while I was parking, I opened a bottle of beer. Okay. And this is when the officer came to me and pulled me over.
This isn't the case, but I got this. I added this at the beginning too. Because this guy parked. He drove somewhere. He parked his car. He's not driving anymore. I could just picture him looking the cop dead in his eye, cracking open a beer and drinking it. He was done driving. He had arrived where he was going to be. He got busted for DUI.
I've done that. And I'm over here and I promise I will never do it again, which was, I don't know, it's wrong. Yeah.
You could have gotten a lot more citations than what you got. So yeah, I don't know why you didn't just wait till you got inside your house. So I can give you a bit of a reduction on the fine. I appreciate you being honest with me. I can reduce it to $120. How much time will you need to pay that?
Or can I have 6 months?
Sure, 6 months to pay. So we'll send you a court order in a couple of days letting you know where you can send your payments.
Thank you, Your Honor.
All right, sir, you're free to go. Okay. Danny Schmidt will be next. Good afternoon. Hello, thank you, Your Honor. Good afternoon, and Mr. Schmidt, you are here. You've got 3 tickets. We're going to start with the one under 25VV12856, citation for expired parking receipt alleged to have occurred on February 6, 2025 here in the city of Tacoma in violation of Tacoma Municipal Code 11.05.707. And just so you're clear, this the next one is going to be, this one is from February 6th, the next one will be from January 28th, and the next one from January 29th. So as to the one from February 6th, the officer saw your car down at 1700 Pacific Avenue, and he, your receipt had expired at 11:14 a.m. and he was there at 11:27, so about 13 minutes. What was going on?
So did you want to swear me in first?
Are you contesting? It looks like you're just mitigating the citation.
Just mitigating.
Dude, you are not the judge here. Just do what you're told.
Yeah.
I don't mean to swear you in then. Okay, so
Okay,
that's the first one.
No worries. So they're all the same. I was working at Starbucks right there in front of those parking spots each time those occurred. I always intend on paying. I always want to pay. I have many receipts of having paid on time, but when we get busy, they do not let us take breaks to go out and pay or even use the app to pay our parking.
All right, this first one I'm gonna let it go. It's just 13 minutes, but the other 2 I think are a little bit different. I'm gonna dismiss this first one. Yeah,
Okay,
trying to
thank
be
you very
very
much.
careful, but the next one is under 25VV9443. This one, you didn't buy a receipt in the first place, it looks like. This one is again from January 28th, 2025 in same location. In this case, the officer took a photo of all the way through from your driver's side to your passenger side, and there just simply is no receipt. What was going on with this one?
That was, I think I had literally parked 5 minutes before that, and I was taking my stuff into work and had not opened up the app to pay yet by the time he walked by.
But you intended to pay?
I do, yeah. I mean, I've already actually paid probably like $200 worth of parking tickets before even bothering to mitigate, but
I'll take your word for it that you meant to pay for this one. I'll dismiss this one. So let's go to number 3. This one is another expired receipt. This one from January 29th, 2025. Officer, in this case, same location, 79 Pacific Avenue. Your receipt expired at 2:43, and this is 4:22. So it's when you got a couple hours that you missed it. Is that accurate?
That's probably accurate. They run really short crews, so if we're, steady, there's just no time, and it probably did happen that way. It was always my intention to pay, but, it happens.
All right, appreciate you being honest with me today. I'll knock that third one down to $15. We'll send you the court order in the near future. That's the only one you need to pay. Can you pay it upon receipt?
Absolutely, yes.
All right, sir. Hope there's some solution other than having to just do a park on the streets down there, but
I have found alternate transportation, so I think those were, I have a scooter now, those were days where it was like snowing and I couldn't get to work.
Good.
And thank you so much.
You bet. Take care.
Take care.
This poor guy, he's like, Judge, I have paid hundreds and hundreds and hundreds of dollars worth of parking tickets. I'm fine paying parking tickets, but this one shouldn't count. Works at Starbucks. Poor guy works at Starbucks and has nowhere to put his car. But he has a scooter now, so it's okay. Oh, I feel bad for him. One of the first things I do when I apply at a job is look at their parking lot. If they don't have a parking lot, no, I'm not going there. No way. Speaking of parking lot, I do have a public service announcement, Donald. If you go to a bar and you're like the last ones to leave at night and you're parked beside the server's car, go home. Don't sit there in your car when she's closing and then she has to walk out to her car with you sitting there and there's no one else in the parking lot. Go home. Go home. Park somewhere else. Park in a different parking lot. But don't stay right beside the server's car after a bar has been closed and just talk to whoever you're with. Go away. Far away. So that she can get to her car safely. She doesn't need you there. Just public service announcement. Oh. So I was expecting someone to come today, but not really. One of my customers, name is Michael. He said today, I'm following you. So I thought he was going to show up today, but Michael didn't. And now I'm going to get him when he comes in next, which is probably going to be when I work Tuesday. All right, guys. We're going to, oh, wait, hold on. I have to pop you over. Redirect, OJ, save. Okay, stream's over. Thank you so much for coming out. CJ, thank you again for waking me up. I appreciate it. You can call sooner if you ever want to. You can call it 401 or 431 or 401. I don't care. I was knocked out. I was watching a trial in Pennsylvania, and it just put me right to sleep. And I didn't transfer any of my videos. I didn't do anything I was supposed to do. I just snored the night away. Maybe I drooled. I don't even know. I was asleep. See you guys at OJ. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night. laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's life.